Good morning, government class. Today is Wednesday, May 6th, and we are talking today about one of the more contentious and argumentative issues in American life, which is the right to of a woman to obtain an abortion and terminate a pregnancy. This is the talking about this, basically, we're talking about the case of Roe versus Wade before the Supreme Court, which was decided in 1973. That's the main case that establishes this right for women to obtain an abortion. Fundamentally, though, what you have to realize is that this is a case that was decided on the issue of privacy, personal privacy versus the police power of the state to protect, to keep citizens safe in terms of their physical body and also morality. Um, this is an issue that people bring up a lot in a lot of different topics, but it tends to, especially when we're talking about the morality side of it, have a lot to do with sex, of course. Um, so when we talk about the police power of the state to protect the privacy of, or sorry, to protect the safety of society, what we're talking about is being able to protect the health of society by regulating alcohol and tobacco sales, by outlawing certain drugs, things like that. Um, we're also talking about the ability of the state to regulate the carrying of firearms or the mandate to wear a seatbelt when you're in a car. When we're talking about regulating morality, though, what we're talking about, among other things, you can be talking about the regulation of gambling, the outlawing of obscene materials, which usually just means pornography, and the outlawing of the practice of prostitution. There is this huge tension. We talk about tensions a lot in American life, and I've talked about this a lot with the history classes as well. But there's this big tension in American life between the police power to keep people safe on the one hand, which is really the truly the main function of government, and on the other, the preservation of individual liberty. And one of the things that we're seeing that play out in right now is all these protests around the country against lockdown laws. Okay, a lot of states have uh, put in place and enforced laws against, going out in public without a mask or against the opening of certain kinds of businesses and things like that. And this is a police power that is being used to protect the public health. But there are people who believe that that is an infringement on their personal rights, personal freedoms to do whatever it is they wish to do. And so you get these protests at state houses around the country, and a lot of them are opening up their states, which I think is a really bad idea right now because I think it's going to have a very bad impact on public health. But that's me, we'll see. So, with the right to privacy, it's noticeable, it's worth noting that Roe versus Wade wasn't so much a decision about morality. There's really no way for the Supreme Court to make a moral decision. And people who disagree with Roe, people who want the right to an abortion to not be a right, generally tend to take a moral argument with that it's wrong to end a pregnancy because they believe that it ends a human life. But Roe was decided on the basis of privacy, not on a moral argument. So, the most controversial applications of the right of privacy have come in cases that raise this question: to what extent can a state limit a woman's right to an abortion? The leading case is Roe v. Wade, 1973. There, the Supreme Court struck down a Texas law that made abortion a crime except when necessary to save the life of the mother. In Roe, the court held that the 14th Amendment's right of privacy, and I quote, encompasses a woman's decision whether or not to terminate her pregnancy. More specifically, the court ruled that One, in the first trimester of pregnancy, about 3 months, a state must recognize a woman's right to an abortion. It cannot interfere with medical judgments in that matter during that period. Two, in the second trimester, in other words, this is months 4 through 6 of a pregnancy, a state acting in the interest of women who undergo abortions can make reasonable regulations about how, when, and where abortions can be performed, but cannot prohibit the procedure. Three, in the final trimester, months 7, 8, and 9 of a pregnancy, a state acting to protect the unborn child can choose to prohibit all abortions except those necessary to preserve the life or health of the mother. Pregnancy is still in 2020 a situation that can, if things go wrong, women do still die in childbirth. Birth is a difficult thing to undergo, particularly for some women. In fact, my wife, when she had her first child, my stepson Adam, very nearly died during that procedure, had to have him through an emergency C-section. So there are cases where a doctor can determine, okay, you know what, if we don't end this pregnancy early, then the health or life of the mother is going to be threatened. Okay, so challenges to Roe. In several later cases, the court rejected a number of challenges to its basic holding in Roe. As the composition of the court has changed, however, so has the court's position on abortion. That shift can be seen in the court's decisions in later cases on the matter. That's something that is particularly relevant right now, given that the Republicans hold the White House and the Senate right now. The Senate is the body that confirms Supreme Court justices, and there are 2 Supreme Court justices, particularly Ruth Bader Ginsburg, on the court right now who are pretty advanced in age and tending to get sick a lot. And these are justices who have been reliable votes to uphold Roe versus Wade and the right to an abortion. So it is widely believed that if, say, Ruth Bader Ginsburg had to retire from the court while President Trump was in office, that she would be replaced by someone who would be willing to strike down the Roe versus Wade decision. In Webster versus Reproductive Health Services in 1989, the court upheld 2 key parts of a Missouri law. Those provisions prohibit abortions except those that preserve the mother's life or health. 1, in any publicly operated hospital or clinic in that state, and 2, when the mother is 20 or more weeks pregnant and tests show that the fetus is viable or capable of sustaining life outside the mother's body. 2 cases in 1990 addressed the issue of minors and abortion. In those cases, a minor, remember, is anyone under the age of 18. In those cases, the court said that a state may require a minor, 1, to inform at least one parent before she can obtain an abortion, in Ohio versus Akron Center for Reproductive Health, and 2, to tell both parents of her plans, except in cases where a judge gives permission for an abortion without parental knowledge, in Hodgson versus Minnesota. The court's most important decision on the issue since Roe v. Wade came in Planned Parenthood of Southeastern Pennsylvania versus Casey in 1992. There, the court announced this rule: the state may place reasonable limits on a woman's right to have an abortion, but those restrictions cannot impose an quote-unquote undue burden on her choice of that procedure. Okay. The Supreme Court throughout the United States history has passed down decisions like this that use sort of vague language, undue burden. Well, what does that mean? What is an undue burden? What is not an undue burden? Supreme Court has a tendency to make decisions or say things couched in language that has to be determined later, has to be interpreted. Okay, is this an undue burden, or is that an undue burden? If a woman wants to have an abortion but has to drive 500 miles one way in order to obtain it, is that an undue burden? Things like that. And that's why we have lawyers. Okay. In Casey, the court applied the new standard to Pennsylvania's Abortion Control Act. It upheld several sections of the law, finding that they did not place a, quote, substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. These provisions, it said, do not impose an undue burden on a woman's choice. The Supreme Court did strike down another part of the Pennsylvania law in Casey, however. That provision required that a married woman tell her husband of her plan to have an abortion. That requirement, said the court, did indeed amount to an undue burden. So a married woman who gets pregnant and wishes to, in Pennsylvania, terminate that pregnancy is no longer required to inform her husband of that plan. Okay. The High Court has decided only 2 abortion cases since 1992. Remember, this book's about 7 years old. I believe that a couple of other cases have come before the court since then, and it is expected that probably within the next year or two, especially if President Trump wins re-election and Republicans hold control of the Senate, that in the next year or two, more defining abortion case would come before the Supreme Court. Its 5-4 vote in the most recent one effectively overturned its 5-4 decision in the earlier case. Together, the 2 cases underscore the impact that changes in the composition of the court can have on the outcome of cases that come before it. The Supreme Court is ideally supposed to be non-political or apolitical. It's supposed to act as a non-partisan judge or referee, if you will, outside of the political process, which is why Supreme Court justices under the Constitution are given lifetime appointments. And it's very difficult to remove a Supreme Court judge through impeachment. Yes, Supreme Court judges can be removed through impeachment just like the president, but once they're appointed, unless they're impeached, they're there for life or as long as they want to be, if they want to retire. In reality, the court has always tilted one way or the other, to the left or to the right. And back in the early 1970s, the court had a more leftward tilt, kind of center leftward tilt. Since the 1980s, the court has been steadily taking a much more right-wing tilt to it, to the point that now, especially if Ruth Bader Ginsburg were to be replaced by a Republican president, the threat to Roe versus Wade would be pretty dire, would be pretty a pretty good bet that Roe could in fact be entirely overturned, just because the makeup of the court has changed over time. All right, hope you guys are doing well, and I will talk to you on Friday. Tomorrow you've got a documentary on Roe to watch, and hope everything's well. Bye-bye.